starting the afternoon session. Good afternoon. Buenas tardes, señor Mayora.
Good afternoon, Mr. Mayora. ¿Puede, por favor, leer la declaración que tiene allí como experto?
Mr. Channel.
Yes, Mr. Chairman. Good afternoon to everyone. I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Mr. Stern.
Thank you, Mr. President. Before I begin, Mr. Foster wanted me to convey his apologies for not being here this afternoon and to assure you that he's not playing hooky. He's working on matters for tomorrow, and that's why he's not here. Good afternoon, Dr. Mayora. Do you have in front of you copies of the 3 expert opinions you have submitted in this arbitration dated June 18th, 2009, October 16th, 2009, and March 14th, 2011?
I believe there are only 2 of those here.
Well, we'll get you the 3rd one in a second. But to move things along, do you ratify the 3 opinions you have submitted in this proceeding and affirm their truthfulness before the tribunal?
Yes, I do.
Okay. Now, I want to first ask you a couple questions that the tribunal has specifically asked the parties to address in this proceeding. And the first one I want to ask you is the question of the president's personal liability or potential personal liability under Guatemalan law for not issuing a Cividad declaration when it has been recommended to him by his legal advisors. Could you explain your views on that topic?
Yes, in my opinion, in a matter of lesividad, neither the president nor his cabinet would be liable for resolving one way or another, basically because although, of course, under our Constitution and our statutes, any public official acting outside the boundaries of the law would be personally liable, severally and jointly liable with the state for the damages caused to any third party. This is a matter of acting illegally, but the law gives the president and his cabinet the powers and the discretion to declare whether an act of government would be contrary to the interests of the state. And this is a matter of discretion. This is a matter where the president and his cabinet are supposed to deliberate and exercise their best judgment and care.
Another question the tribunal has asked the parties to address is whether under Guatemalan law is it permissible for the government and the affected private party to negotiate a way or reach a settlement agreement on a declaration of lesividad as opposed to having to wait for the administrative court to confirm or reject such a declaration. Could you set forth your views on this issue?
Yes. The law, the statute that regulates the Office of the Attorney General does provide for the possibility of the President of the Republic issuing instructions to the Attorney General's office to enter into negotiations conducive to a possible settlement. However, in this particular case, it is my opinion that since the explanatory statement that's in the record that supports the issuing of the declaration of lesivo has been founded on legal technicalities or on alleged illegalities, then this has made it impossible to enter into negotiations conducive to a settlement because, as it were, you cannot say, well, give me this much money and I'll forget about this legal requirement or that other legal requirement not being necessary. So therefore, in my opinion, the way in which the declaration of lesivo was issued in this particular situation, the possibility of entering into negotiations conducive to a settlement became foreclosed or was made impossible.
Now let me ask you a question about a different issue. Respondent's Guatemalan legal expert, Mr. Aguilar, has opined that contracts 143 and 158 were absolutely null and void ab initio under Guatemalan law. And he further insists that a declaration of lesividad was the only legal means available to the government of Guatemala to seek the nullification of contracts 143 and 158. In your opinion, is Mr. Aguilar correct?
I must respectfully disagree with my colleague because the legal order of Guatemala, as I believe is the case in most continental European legal systems, affords specific actions in order to claim that there is either absolute nullity or relative nullity. And in case it would be an administrative contract that is believed to be either voidable or absolutely null, the action would have to be taken to the administrative court, el Tribunal de lo Contencioso Administrativo. And in case it were a civil contract, that usufruct happens to be a civil contract, the matter should be taken to a civil judge in order for the judge to declare whether there is absolute nullity. In my opinion, a declaration of lesividad is an exceptional means to analyze any kind of nullity, whether absolute or relative, because it is more, in my opinion, a legal means for the state to exceptionally go back and repudiate its own acts because it considers the consequences of those acts to be contrary to the interests of the state. And this is an exception in a number of ways, but most importantly, it is an exception because usually, as it is provided for in our civil code, usually the one party that has intervened to create or to at least produce a cause leading to nullity cannot pursue an action to have that declared. So lesividad is clearly an exception, and it is exceptionally utilized in order to examine whether some act has been contrary to the interests of the state.
Let me ask you about a different subject. In paragraph 21 of his first expert report, Mr. Aguilar argues that the specific state interest which was harmed by contract 143 was the rule of law. And then in paragraph 83 of his second expert report, he argues that the specific state interests that were harmed by contract 143 were the loss of usage and usufruct of the railroad equipment which was appropriated by Ferrovias. In your opinion, were either of these alleged state interests appropriate grounds for declaring contracts 143 and 158 harmful to the interests of the state?
No, in my opinion, neither could be reasonably considered as being a basis for such declaration of lesividad. As it pertains to the principle of the rule of law, this is a very fundamental principle of the whole legal system in the Constitution and in the laws of the Republic. It is a lot more important and of a lot greater entity than just the interest of the state. It is the fundamental basis of the whole system, and it's the notion that every public official, that every governmental agency, that every state entity must abide by law, and that where any infringement or any violation would take place, then the affected parties would have access and recourse to an independent court of justice so that the wrongs be righted. So the rule of law is an overriding principle, and it's a lot more important in every sense than the interest of the state. Secondly, as regards the loss of usage as it's being worded in the paragraph that you mentioned, well, I fail to understand how this could be a reason to declare the contract harmful to the interests of the state, because you cannot possibly, as our government did, you cannot possibly call for an international public bidding process in order to hand the administration and the operation of the railway system to the private sector without losing the usage of the railway equipment. It would be a contradiction in terms to say, well, I want the railway system to be run by a private company, and then at the same time I want to keep the usage of the railway equipment. It is simply not possible.
Respondent's expert, Mr. Aguilar, argues that contracts 143 and 158 were lascivo and absolutely null and void under Guatemalan law because the contract was not awarded pursuant to a new public bidding process, and it was never approved by the President by executive resolution. Do you agree with Mr. Aguilar?
No, I think that is not right. I don't agree with that view for some few reasons. The first one is that the bidding process that's being discussed here is a process that led to the negotiation of a usufruct contract. If one looks at the bidding terms of reference, what one finds that the winning bidder had the right to sit down and negotiate a usufruct contract within a certain framework. Therefore, there was a clear winner. No one has contested that Ferrovías was the winner of the bid, and so they sat down to negotiate Contract 41, and then, as the tribunal knows and has heard arguments and a number of presentations, this led to a number of events that finally materialized in contracts 143 and 158. And the way I see it is that this is a process of negotiation that, as it is declared explicitly in those two contracts, is the consequence of that bidding process. This is not an independent negotiation. These are not independent contracts that have been signed or executed by FEWA's overseer on his own volition. These are the ultimate consequence of that bidding process. And as to whether these contracts are absolutely null and void because of a lack of a second bidding process, well, I think that this is again contradictory, because if one alleges that a second bidding process is required, one is saying that the initial one didn't suffice to enter into the agreement that is being examined. So, in my opinion, the notion that a second bidding process was required misses the point that this has been a continuum leading ultimately to those two contracts.
And just, what about executive approval? What is your
Oh,
views
yes.
on that?
Well, yet again, I think that to say that the president or his cabinet or the government didn't approve of these processes is impossible. The president and his cabinet issued an accord that's in the record explaining why the government had decided that a number of services and state companies had to become privatized or desincorporated, as it was also called. It explains why the government has decided to go on and pursue this path of privatization. And if one reads the terms of reference for the bidding process, one finds again that it is the government of the republic, not the overseer of FEWA, that has decided to pursue this privatization and to pursue this bidding process and these agreements or contracts with the winner of the bid. And so there is clearly a presidential approval there. It is explicit in most all of those documents leading to the bidding process and its consequences. So, to be more precise, what's being claimed here, I think, is that an ex post ratification didn't take place. Now, the point is that there isn't any rule, there isn't any statute requiring an ex post ratification. But an approval there was, and it is mentioned everywhere, and this is a project that our government was promoting and trying to get to completion.
Thank you, Dr. Mayor. You can now answer questions from Guatemala's council.
Mr. Horta.
Thank you, Mr. Chairman. Good afternoon, Dr. Mayota. How are you?
Fine, thank you. Good afternoon, Councilor.
I'd like to reconstruct a little bit what may have been the situation for President Berger when he took this decision. In order to do that, I want to walk you through a little bit of the chronology of what happened leading up to the point where President Berger was asked to make the declaration of lesividad with respect to contracts 143 and 158. To do that, I'd like to show you some documents. We're putting before you some notebooks. Don't be alarmed by their size. I'll point out to you the documents that we're going to discuss, and we'll also put them up on the screen. Okay?
Yes, sir.
All right. First of all, you're aware that the decision made by the President to declare contracts 143 and 158 lesivo arise from a request made by the overseer of FEGUA, correct?
Yes, sir.
That request was made to the overseer of FEGUA in January of 2006, in particular 13th of January 2006. You recall that?
Made to the overseer or by the overseer?
Made by the overseer to the President on that date, January 13, 2006.
I don't know the exact date, but it's about that time, yeah.
Okay. And do you recall that, I assume you've studied the record in some detail?
Yes, I did.
So then you probably recall that the overseer of FEGUA, Dr. Gramajo, started looking into the defects with contracts 143 and 158 when he was first told about those by his legal department back in the beginning of 2004, just after he entered into his charge as the overseer. You recall that?
I have seen letters or opinions of FEWA's legal department to that effect.
Okay. And after a series of negotiations with Ferrovias in an attempt to reach a resolution of some of the legal defects associated with Contract 143 and 158, there came a time when the parties basically reached an impasse in relation to those negotiations. Do you remember sort of generally seeing that in the record?
I understand that there were meetings and there were negotiations. Whether those meetings and negotiations were, leading to curing legal technicalities or leading to other sorts of purposes, I don't know.
Okay. Fair. You didn't participate in them.
Right.
Okay. Now, in April of let's take a step back. In April of 2005, do you recall seeing in the record that Dr. Gramajo sought the legal opinion from the Chief Legal Counsel of the Ministry of Communications?
Yes, I do remember that.
Gabriela Sacrison, you remember seeing that letter where he was seeking her advice on the issue of the whether the Contract 143-158 was lesivo or not?
Yes.
And do you recall that as a result of that inquiry, the Ministry of Communications hired an outside law firm, Palacios y Asociados, which is a law firm based in Guatemala, correct?
I recall seeing documents signed by them. I don't know whether there was any hiring as a consequence of this, but it sounds like a normal thing to do. Yeah.
Okay. And do you recall seeing, I think it's Exhibit C-105, an opinion that they rendered telling the overseer, well, telling the Ministry of Communications and the overseer of FEGWA that, in their opinion, in their professional opinion, Contracts 143 and 158 were lesivo for a number of reasons?
Are we talking about the Palacios opinion?
Yes, sir. Yeah, we have it up on the screen now. This is document C-105.
I'm not sure that I've seen this opinion, but
okay. Well, you don't doubt, do you, that this law firm was asked by the Ministry of Communications to conduct an independent inquiry into whether Contract 143 and 158 was lesivo, and they came back with the opinion that for a number of reasons as set forth in document C-105, they were of the view that the document, A, suffered from a number of important legal defects, and B, that it was lesivo. Those defects made the document, the contract 143-158, lesivo to the interests of the state.
they might have been hired for that, and they might have given that opinion. Yeah.
When you say they might have been hired for that, you're not suggesting that they were hired to reach that conclusion, are you?
No, to inquire into those matters.
Okay. Now, once this opinion was transmitted back to the Ministry of Communications, Overseer Gramajo reached out to the Attorney General's office. Do you recall that? In June of 2005, he sent a request to the Attorney General of Guatemala, and just so that we're all clear, that is the highest legal authority in Guatemala, correct? For Guatemalan law.
Well, highest legal authority depends.
For the state, I should say.
As an advisor for the state, yeah.
Okay. Fair enough, because there's a constitutional court and others that may be deemed higher, would be deemed higher. So you recall that in August of 2005, the Attorney General's office of Guatemala sent back their opinion and reached the conclusion that contracts 143 and 158, for a number of reasons, was lesivo to the interests of the state.
I do remember having read an opinion on behalf of the Office of the Attorney General. Yeah.
Okay. Let's put up R15. Do you recall that the opinion read, basically reached that conclusion that I just set forth for you?
Yep.
Okay. And in their opinion, or in his opinion, the Attorney General and his staff who assisted him with this analysis highlighted a number of important legal defects in Contract 143 and 158, including the fact that it didn't result from a separate bidding process, correct?
Yes, they do mention those kinds of arguments. I don't find them important and or wouldn't qualify them as important in the context of this case. But yeah.
Well, they certainly are important in the contents of this case because this is part and parcel of the information that was given to President Berger when he made his decision. Isn't that correct?
Yeah, but it is not important that there wasn't a subsequent ratification when one is considering the very fundamental question of the interests of the state.
We understand that's your opinion.
Yeah, that's
But remember,
that's what I'm saying.
Right, and I'm not asking
that
you.
might have been their opinion, but it is not mine. Yeah.
Very good. I'm not asking you for your opinion about that conclusion right now.
Okay.
I'm simply setting the stage for what fell at the president's doorstep when he was asked to declare this contract lesivo. And one of the things that was at his doorstep was the fact that the Attorney General of Guatemala, the highest legal advisor of the state, reached the opinion that this contract, 143 and 158, was full of a number of important legal defects, correct?
That was his opinion, yeah.
Yes. And that, therefore, it was lesivo to the interests of the state, correct?
Well, not that it was, but it should be declared.
So in his opinion, he told the president through this opinion that he thought the president should declare the contract lesivo given the legal defects that had been identified in the opinion.
Yeah, that's right.
Okay. Now, after this opinion was transmitted back to the FEGWA overseer on the 1st of August 2005, eventually the FEGWA overseer, after consulting with his in-house legal department and outside lawyers, wrote to the president, we talked about this before, on January 13, 2006, and asked the president to declare the contract lesivo, right?
Right.
And the tribunal has seen the letter, and you're familiar with it, I assume, correct?
I am.
And that letter identified a number of legal defects and sought the president's determination about declaring that contract 143 and 158 lesivo to the interests of the state, correct?
Mm-hmm.
You have to answer verbally.
Yes, correct.
And when the president received that request, he then dispatched his legal office to study the question, right?
That's right.
And one of the things they did was they sent the contract to the office of the Ministry of Public Finance. Or I'm sure if I'm misstating the name, but
No, that's correct.
is that correct? Okay. And that, just so we're clear, that office, or that ministry, I should say, is the ministry in Guatemala that is charged with making determinations about legalities of administrative contracts, correct?
No, that is not exactly right.
Well, isn't that the ministry, and correct me if I'm wrong, this is, you're the expert on Guatemalan law, but isn't that the ministry who is responsible for assuring that administrative contracts are appropriate under Guatemalan law?
No, that would be, actually it would be rather the Office of the Attorney General. The Ministry of Finance has to do with handling the budget, handling the finances of the state, and overseeing the correct execution of the budget of several public administrations of the state.
Now, so in your opinion, do you have an opinion as to why the contract was sent to that ministry?
Well, there is a division or a department in the ministry having to do with the so-called bienes del Estado, you could probably say property of the state. And I recall that it was sent to that department for an opinion.
Okay. And I guess in the nature of trying to make a determination about whether property of the state had been harmed as a result of the actions undertaken in relation to Contract 143-158, it would be natural to seek the opinion of that ministry and that division within that ministry to see what their opinion was about whether there had been, in fact, harm to property of the state, correct?
I wouldn't have, but that's how they proceeded. Yeah.
And they actually have a government procurement department within that ministry, don't they?
Yeah, they do.
And that is the department that was consulted on whether Contract 143 and 158 was or was not lesivo to the interests of the state, correct?
Yeah, I think so.
All right. And you recall that there were three separate persons within the Ministry of Finance who analyzed Contract 143 and 158?
Yes.
And you recall as well that those three persons reached the opinion, after doing an independent analysis, that Contract 143 and 158 was, well, one, suffered from a number of important legal defects, correct? And if you don't recall, we can look at the opinion.
I'm sorry, we were asking me, you're just describing what's in the documents.
I'm asking you if you have a recollection that three separate persons within the Ministry of Finance, the Department of Public Procurement, analyzed Contract 143 and 158 and reached, each of them, a determination, an opinion, that Contracts 143 and 158 suffered from a number of important legal defects. Do you recall that?
They issued a few very succinct opinions to that effect, yeah.
Okay. I mean, by saying they were succinct opinions, you're not in any way suggesting they didn't do a careful analysis, are you?
That's how it looks on the face of those opinions to me, yeah.
It looks as though they didn't do a careful analysis?
Very superficial analysis, yes.
Okay. Let's put up, what is, I'm sorry?
R24.
Document R24 for purposes of the tribunal. Let's go ahead to the beginning of the opinion. Are you aware that one of the persons who authored this opinion has testified in this case?
No.
If we could go to the, sorry, Kelby, if we could go down to the very end of this document. And America Gonzalez, who you can see is one of the persons who, this is obviously the English translation of the document, but one of the persons who conducted the analysis and signed this legal opinion, correct?
Yeah, I see her name there, yeah.
And she submitted and we're going to show you in a second her declaration. She submitted a declaration in this case saying that she conducted, as well as her colleagues, very careful analysis of Contracts 143 and 158.
I'm going to object to the extent, if he wants to show him the witness statement, that's fine, but I object to him characterizing a statement of a witness which hasn't even testified orally in these proceedings.
She
And
conducted.
he's testified he hasn't seen the statement at all.
So, Dr. Mayota, Ms. Gonzalez has testified in this case, and we'll
Excuse me,
show.
could the tribunal please address my objection? Thank you.
You know what? I'll just move on without characterizing her testimony for the sake of speed. I'll put up her declaration in a second. So Ms. Gonzalez has testified in this case. We'll show you her declaration in a second. But nonetheless, she and her colleagues reached an opinion that there were grounds to invalidate Contract 143 and 158 through the issuance of a lesivo declaration, correct?
Again, objection. He has not seen her statement. He knows nothing about it.
I'm
He's
asking
asking
you-
about whether he knows what her testimony is.
Either you put the testimony up, otherwise you have what the opinion is here, and can't you
Okay.
just
Yep.
limit it to he's a legal expert, and you have the opinion of the person in question signed here.
I think it's
Can
just
you
a matter
limit
of a
the
misstep on
questions?
my part, Mr.
Yeah.
Chairman. I meant to ask about the opinion itself and not about the testimony. I'll get to the testimony in a
So
second.
why don't you ask about
Sure.
the opinion?
Sure. So you don't dispute that she and her colleagues issued an opinion analyzing that and reaching the conclusion that the contract 143 and 158 suffered from a number of legal defects that rendered or provided the state with grounds to invalidate that agreement through a lesivo declaration, correct?
That's correct.
Now, you were not there when they conducted their analysis of this opinion, right?
No,
You have no idea how many hours they spent on it.
no.
So when you say it's a succinct opinion, you're rendering that conclusion based on your review of this document, but again, you have no idea how intensive an analysis they each conducted to arrive at this opinion, right?
No, that's why I said that on the face of this opinion, there was a very superficial analysis of this problem.
Right, but as I say, you have no personal knowledge as to the extent of the analysis that they conducted, so you can't render an opinion that it was superficial, correct?
I don't know how many hours they spent, no.
Okay. Now, this opinion also was sent back to the Office of the Secretary General, and just so that the tribunal understands, the Office of the Secretary General within the Office of the Presidency is the office that is in charge principally of legal affairs for the Office of the Presidency, correct?
Well, they have to review from several different perspectives, including the legal perspective, the dispatch that goes to the President.
And there's a figurehead, not a figurehead, that's not the correct term, there's a chief lawyer, the equivalent of what would be, for example, the White House counsel here in that office, and that's the Secretary General, correct?
The Secretary General has a head of his legal department.
He's the head of the legal department for the Office of the
The
President.
Secretary General is a Secretary General, and he has a legal department, and there's a chief of that legal department.
Okay, and he is the boss or he's a lawyer usually, right? He or she's a lawyer.
Usually, yeah.
And they are the boss of the chief lawyer for the Office of the Presidency, for the Office of the Secretary General, correct?
That's right.
And that is the top legal advisor, if you will, for the President, for the Office of the Secretary General.
Well, I think that it depends on a number of circumstances, but because, of course, the Attorney General, as we have concurred, is the chief legal advisor. So, I think it depends on the circumstances and the context, but you can say the Secretary General is a very important official in terms of what the President does or doesn't do, including within the context of the legality of the discharge of his functions in office.
And including, for example, with respect to the President, making a determination about whether or not to declare a contract lesivo.
I would say rather in terms of what are the rules and what's the framework within which the President and his cabinet ought to make that determination or not.
Right, but my question wasn't about the rules and the determinations. It was about whether that person's opinion would carry significant weight in the President's determination about whether to carry forward with a declaration of lesividad in relation to a contract.
Objection calls for speculation about whether some unnamed persons could carry significant weight in the President's determination. It's an improper question.
Hold the objection.
Let's try it again. In your opinion, based on what you know about Guatemalan law, would the President, in your opinion, place important weight on the opinion of the Secretary General in the Office of the Presidency on the issue of whether or not to issue a Lesivo declaration?
Objection. Again, this is not a question of Guatemalan law. It's a question of the dealings between the President and his advisors in some unnamed administration.
Is sustained as before.
Very good.
If I can help, the question is not what he might do, which is speculation. The question is what he's entitled to do, surely.
Well, I'll just move on, and then we'll get to that in a second. Okay, so this opinion was returned to the Office of the Secretary General, correct?
Correct.
And they then conducted their own independent analysis based on all of the information they had received as to whether contracts 143 and 158 were Lesivo, right?
They did conduct an analysis with how wide and how deep, I don't know.
Okay. And they reached the opinion, I don't know if we can put that up, it's R25, on the 26th of April, 2006, the Technical Board of the Presidency within the Office of the Secretary General reached the opinion that contracts 143 and 158 were Lesivo to the interests of the state, correct?
Wrongly they did, yeah.
And they reached that conclusion based on a number of legal defects that they identified in contracts 143 and 158, right?
Yeah, again, wrongly they did, yeah.
Yes. No, I realize you, as just so that we're clear, all of these different persons that did these analyses, the Attorney General of Guatemala, the 3 persons within the Ministry of Finance, the outside law firm, the persons within the Technical Board of the Presidency, they all concurred that contracts 143 and 158 suffered from legal defects that rendered the contract Lesivo. You believe they were all wrong?
No, I believe that the determination of whether an act of government leading to a contract is or not harmful to the interests of the state, it's a matter of policy, and it's a matter of analysis and judgment for the President and his cabinet to make within the rules of a constitution and within the legal framework of the state. What the legal advisor has to advise on is whether the conditions, the legal conditions to enter into such analysis leading to a possible determination that that act of government or that contract or whatever are harmful to the interests of the state is the limit of their competence. They are not there to tell the President, Mr. President, I think you should declare this Lesivo, because that is none of their competence. The competence to make such determination is that of the President of the Republic and his cabinet.
Right. I understand that is your opinion. Let's go to the conclusion here. Nope. If we could highlight the opinion. And the opinion of Selena Osaeta, who then was the legal advisor for the Technical Board of the General Secretariat of the Presidency, as well as Manuel Duarte, both of whom have rendered testimony in this case through declarations, is that after analyzing the accompanying documentation, and they cite it earlier up in the opinion, and the applicable legal provisions, this consultative committee understands that the draft governmental agreement, and just so that the tribunal is clear, because this is a translation, when they say draft governmental agreement, they're talking about the draft executive resolution declaring the contract Lesivo, right? That would have been attached to this document?
I'm sorry, I thought you were talking to the tribunal.
No, I'm asking you a question.
Can you
I'll ask
please
it again.
Yeah.
Sure. When in the opinion, they refer here to the fact that they understand that the draft governmental agreement, which declares lesivo to state interest, the contracts, that's a reference to the draft executive resolution declaring the contract lesivo, right? That would have been attached to this
I would
opinion.
assume that's what's meant here.
And so they reached the opinion that after analyzing the applicable legal provisions and the other documentation which they analyzed, that the executive resolution declaring lesivo to the interests of the state, the contracts, should be submitted to the President for approval, correct?
Mm-hmm.
For his approval in Cabinet of Ministers, right?
Mm-hmm.
You need to say yes.
Yes. Sorry.
And are you aware, have you reviewed the testimony, for example, of Mr. Duarte and Ms. Osaeta?
No, I don't recall having read those testimonies.
Okay. Let's go ahead and put up Ms. Osaeta's testimony just as an example. And you have all of this, sir, before you in your binder if you'd like to look at it in paper copy, but we're also putting it up on the screen. Okay, this is a translation of the statement of Selena Osaeta. Let's go down. She states her qualifications there. Keep going down, please. Keep going. Okay. Let's look at the opinion, what she says about her opinion. If we can go down a little bit more, Kelby, please. Okay, a little more. All right, so she says, I have 15 minutes left. Oh. So she says she reviewed a number of things in order to reach her opinion, and she states them there in paragraph 13, correct?
I'll take a minute to read it. Well, what I see that she read here was 4 or 5 opinions, not the entire file, but anyway.
Okay. And in paragraph 15, she states what her conclusions were, as well as that of the other persons who signed her opinion, right?
I'm going to object to the relevance of this testimony if he's asking him to comment on witness statements that he hasn't read and has not offered any views or opinions on in his reports.
Well, the relevance is pretty clear. We're here in part to determine whether the President, when he declared the executive resolution, contracts 143 and 158 lesivo to the interests of the state, did so reasonably. And part and parcel of that decision was the information that was put before the President when he made that decision. So I'm entitled to ask about this on their expert on the issue of whether or not lesivo was proper.
That's not the question that Mr. Mayor has opined on, or Dr. Mayor has opined on. He's asked, as a legal matter under Guatemalan law, whether the President was compelled, as a matter of law, which their witnesses have asserted, both factually and experts, as a matter of law to issue the declaration because it was recommended to him by his advisors. It's not whether it was reasonable or not reasonable. He has no testimony in that regard or any opinions on that regard.
The objection is sustained.
Okay. Now, sir, you understand, do you not, that after the President, or after this opinion was issued, it was given to the President, it was given to the Secretary General, who then had to advise the President on what he believed at the time the President should do in relation to declaring the contract lesivo or not, correct?
Yes, the ordinary course of those kinds of proceedings is that the legal opinions go to the Secretary General.
And you're aware, I assume, that that Mr. You know who Mr. Jorge Arroyave is? Yes, I'm sorry. Jorge Arroyave. Do you know who he is?
I don't think I do.
Well, at the time, he was the Secretary General to President Oscar Berger.
Okay.
And Mr. Arroyave informed President Berger that it was his opinion that the President should declare Contract 143 and 158 lesivo, or he would incur in personal responsibility. Are you aware of that?
Objection. Statement. There's no testimony in the record on that. That's his counsel testifying in this case.
Well, I'll show you the testimony now.
Excuse me, which witness is this?
This counsel is Mr. Fuentes, who testified in this case, Mario Fuentes, and I'm putting before this witness the testimony of Mr. Fuentes, where he said he spoke to Mr. Arroyave, who told him that he had advised the President that he had to sign the lesivo declaration to avoid any future legal consequences.
Well, that is not firsthand testimony from Mr. Arroyave saying he told the President that. It's him relaying a conversation to Mr. Fuentes, who described it in his testimony. So,
And there's
again,
no,
that is not competent evidence to
Well,
ask the witness questions about this.
if that is not competent evidence, with all due respect, their entire case is built on hearsay. Their entire case, everything they've put before you is what somebody told somebody else who told somebody else. I'm entitled to question this witness. This is unrefuted in the record, that the President's top legal advisor was of the opinion that contracts 143 and 158 were lesivo, that he counseled the President about that. This was testimony that the tribunal has heard.
It's a question of fact what the President was advised.
Right, and this
This witness is not here as a fact witness. He's here as an expert witness on questions of Guatemalan law.
well,
You haven't asked him a question of Guatemalan law up to now.
right, I'm leading up to the question where I'm going to ask him his opinion, and I'm setting the foundation for that.
Yeah, but surely you can stipulate these are questions of fact. You stipulate the fact is that this cloud of witnesses, cloud of opinions was given. And if there is then a question of Guatemalan law, for which that is a predicate, you can ask it. But at present, all you're doing is asking him questions of fact.
Well, sir,
In other words, just
a second. Yeah.
in other words, just you stipulate the facts and ask if he, as a legal expert, agrees with what the Attorney General purportedly advised.
yeah, and with all due respect, Secretary Eisenstadt, I don't, it's not, in my view, so relevant whether he agrees with what the Attorney General concluded. I believe what's relevant, and the tribunal can tell me if they're not interested in hearing about this, is what information was before the President when he was asked to declare the contract lesivo.
My point is he's not an expert on that question. I'm sorry.
Right.
He's not an expert on that question. You're entitled to stipulate, and if it's in the record, that's fine.
Okay.
This information was before him. What you've got to do, he's a legal expert on Guatemalan law. You've got to put to him a proposition of Guatemalan law that follows from those premises.
Very good. So I'll get to that. So now, Dr. Mayota, in the face of assuming that the record establishes that the President was advised by his Secretary General that he would incur in personal liability if he didn't declare contracts 143 and 158 lesivo, that he had an opinion from his secretary, the technical secretary board, that the agreement was lesivo, assuming those facts and everything else that I've just set forth in the questions, do you think it was reasonable for the President to reach the conclusion that he should declare contracts 143 and 158 lesivo?
Objection. This is, again, it's not a question of Guatemalan law. This is a question of reasonableness, which is not something that Dr. Mayor has opined about. It's not a question of Guatemalan law.
I thought I was cross-examining an expert. I think it's quite fair to ask him that question. I mean, he can tell us what his opinions are about whether the contracts required or didn't require a public bid. The bottom line here is that every other person who at the time looked at the issue reached the opinion that the contracts were lesivo. The President was advised that and told that he would incur in personal liability if he didn't declare the contract lesivo. And I would like to know if this expert is of the view that it was unreasonable for the President to reach the conclusion that he should declare the contract lesivo.
That's a question in the case, because we're not concerned with the liability under Guatemalan law, we're concerned with the liability under the CAFTA.
Right, and I would like to know under Guatemalan
this man
law.
isn't putting himself forward as an expert on CAFTA.
Right, and I'm not asking him as a matter of public international law. I'm asking as a matter of Guatemalan law. Does he believe it's unreasonable for the President to have reached the determination to declare the contracts lesivo, given all of the facts that we have just set forth?
And a reasonableness is not a standard or a law under Guatemalan law. There's nothing at issue here with regard to reasonableness as a matter of Guatemalan law.
Just go ahead and ask the question.
Oh, I think, do you
Yeah,
remember the
well,
question?
You have asked it, but sorry, the witness may answer.
In my opinion, assuming those facts, the President would have been wrong to believe that he is, or would have been liable, because again, the very few legal provisions having to do with a declaration of lesividad are based on the notion of harm to the interest of the state, and the determination of whether those harms to the interests of the state have taken place or not are the competence of the President and his cabinet, not the competence of legal advisors or the Secretary General. They have to tell the President what's the legal framework within which him and his cabinet can make any such determination. Going in one direction or the other is a matter of judgment, and that judgment, the one who's called to exercise the judgment under the oath that he took, is the President and his cabinet.
Do you believe it was unreasonable for the President to, under Guatemalan law, for the President to have made the determination to declare contracts 143 and 158 lesivo in the face of the facts that we've just discussed? Yes or no?
Yes, I do, and I do because it would have been very unreasonable as well if the Secretary General tells him, look, as a matter of financial policy or labor policy, I think they're going to be liable unless you raise the minimum salary to this point. That's a matter of policy. That is the President's call, not the call of his advisors or of the Secretary General.
Do you agree, sir, that public officials, in Guatemala, when they take their oath, they take an oath to uphold the Constitution?
Yes, it's in the Constitution.
And they take an oath to uphold the laws of the Republic?
Yes.
And do you agree that when a public official comes into knowledge that a contract appears to be illegal or absolutely null or annullable, then that public official has to take a number of actions in order to have the competent authority within Guatemala initiate legal actions against that contract?
It has to take the appropriate actions through the appropriate proceedings, and if he wouldn't, he would be liable.
Okay. And here, the President took the action of declaring the contract lesivo, having been told that the contract was illegal, right?
And that is an inappropriate action, in my opinion.
Inappropriate.
Yep.
But isn't it true, sir, that at the time that the President took that action, that was the only means available to the President under the appropriate laws in Guatemala for him to instruct the competent authority to take legal actions against that contract? Isn't that correct?
No, that is not correct. As a matter of fact, it's been maintained that there was absolute nullity here. And the statute of limitations for absolute nullity never expires. And the Attorney General not only has the power, but the obligation to pursue any such action if he thought that there is absolute nullity.
Declaring the contract lesivo certainly was one option the President had, right, in order to have the competent authority determine whether the contract was lesivo? Isn't that correct?
I think your question is circular, but probably you can clarify to me, because are you leading to nullity or to lesividad? Because lesividad cannot be a declaration in order to establish lesividad.
Well, in order to reach the question of nullity, the President, one of the options he had was declaring the contract lesivo, correct?
Not in my opinion. You see, a problem of legality is for the courts and the other officers and officials of the Republic that are charged with what we call control of legality. A determination of whether the interests of the state have been harmed is a matter of judgment of the utmost importance that's been placed in the office of the President of the Republic and his cabinet. It is weighing interests of the state. It is not a matter of legality.
Okay. Let's go to your first opinion, I believe. And let's look at paragraph 9.6, please. And if we could blow up paragraph 9.6, not that much. Okay. And let's go ahead and we can highlight it in yellow, if possible, Kelby. It's not a big deal if you can't. Okay. All right. Now, you say in paragraph 9.6 that you say these questions or any other legal question could have been raised by the Office of the Attorney General when it examined the documents and proceedings prior to the public bidding or before the expiration of the statute of limitations of, within parentheses, of 2 years, according to Article 1312 of the Guatemalan Civil Code, in order to file a civil action seeking a declaration that Contract 143 and 158 be declared null and void. You go on to say, the reason why none of this was done is of no relevance, except that the failure of the Office of the Attorney General to take any legal action, supposing any of these allegations warranted such thing, within the time frame specified by law, rendered the whole matter firm and definitive. And then you conclude by saying the only way to seek the nullification of contracts 143 and 158 was to show that their execution or provisions were harmful to the interests of the state, not merely illegal, correct?
Correct.
And so what you're saying there is that the only way to seek the nullification of the contract was for there to be a determination that the contracts were lesivo, right? That's what you said.
What I've said now, answering your question and what's written here are both correct and are not contradictory. And what I'm saying is that if it were true that there was absolute nullity, which is not what's being referred to here, this is relative nullity, which there's a statute of limitations expiring in 2 years, but if it were true that there was absolute nullity, then there is no statute of limitations. And I'm also saying here what I just mentioned to the tribunal, namely that a declaration of lesividad does not pertain to questions of legality. It pertains to the interests of the state. That's why it is given to the President and his cabinet to make such determination and not to a court of law. If there's a problem of legality, then it is a court of law that must determine that
Right,
problem.
and legalities, as you've told us before, when you testified here in the prior hearing, a legality can cause, an illegality, I should say, can cause harm to the interests of the state, correct? Or are you of the view that an illegality under Guatemalan law can never cause harm to the interests of the state?
Well, I think that a situation where there are illegalities and there are harms to the interests of the state can, of course, coexist. Can.
And in this case, the president made the determination that the illegality did coexist with the harm, didn't he?
I don't think he did that.
Well, sure he did, because he declared the contract lesivo, didn't he?
On the basis of legal technicalities.
Well, you call them legal technicalities, sir, but the president reached the conclusion that those legal defects caused harm to the state, didn't he?
No. I think that what he did, if one pays attention to the explanatory statement, is to make it one and the same thing, lesividad and illegality. And that's technically wrong, and he was wrongly advised, unfortunately.
Okay. Now, sir, you testified about the fact that the president, is it your opinion, under Guatemalan law, that the president had no obligation to respond to the advice that he was given that contracts 143 and 158 were illegal? Is that your testimony?
Can you repeat it, please?
Sure. Is it your testimony in this case that President Berger had no responsibility, didn't have to, let's say it that way, had no obligation to respond to the advice that he was given that contracts 143 and 158 were illegal?
He was under no legal or constitutional obligation to declare them lesivos.
Did he have an obligation to respond to the advice that he was given that the contracts were illegal?
He had an obligation to consider with his cabinet that question, given the fact that there had been a proceeding leading to bringing that question to him and his cabinet.
So you agree he had an obligation to take action?
To deliberate and to decide whether to declare or not to declare.
Okay. And you obviously take issue with his decision to declare, right?
I take issue with the foundations that led to his decision and his cabinet's decision.
But then, I see. So you believe he was misinformed, but you don't take issue with his decision to declare it lesivo, is that correct?
I think that to have exercised his judgment on the basis of illegalities or legal technicalities was not even a right exercise of judgment. It was not valid under our Constitution and our laws.
Let's pull up Article 154 of the Constitution. Mr. Mayota has cited it in some of his opinions, and this is RL, I think, is 70 the Spanish version? Or the English version? RL 45, I believe, is the English version. Yes.
Is the
Yes.
English version.
RL 45, it's right here. Yeah. Okay. And for the tribunal, these are two articles that we believe, Article 154 and 155, and it is, I believe, RL 45 is the English translation of portions of these articles. This is, these are articles for, 154 and 155 of the Guatemalan Constitution. Yeah, so not 153, 154, and 155. So Article 154, sir, states that government employees are vested with the authority, and are legally responsible for their official conduct, correct?
That's correct.
And you agree that this article applies to the president?
Of course.
So you agree that he's legally responsible for his official conduct?
He's legally responsible for his official conduct, yes.
And Article 155, if we can highlight the first full paragraph of it. This article says, when a state dignitary, state official, or state employee in the exercise of his or her position breaks the law to the detriment of a private individual, the state, or state entity where the dignitary, official, or employee serves, and this is actually it's a poor translation. It should say, he shall be jointly liable for damages. You can read the Spanish version if you'd like, but it says, será responsable. You agree with that? That if the president breaks the law to the detriment of the state, or a state entity, or a private individual, he could be jointly liable for damages as a result of that conduct.
Well, it says here to the detriment of a private individual.
Or to the detriment of the state, correct?
The state or a state entity, yes.
Right. So it could be to the detriment of just the state. If he breaks the law just to the detriment of the state, he could be personally liable, correct?
I think we had better look at the Spanish
Not a problem.
version of it.
I believe it's in your notebook under C, let me see, RL.
45.
You sure?
I think I'm right. It is only to the detriment of a private individual.
Could you read out loud, just for the record, that paragraph in Spanish, please, so it can be translated for the record?
Yes, sir. Artículo 150.
Article 155. Liability due to breaches of the law. Whenever an official, employee, in exercise of his own, by complying with his own duties, infringes the laws in the exercise of his position to the detriment of a private individual, the state or state entity where the dignitary, official, or employee serves shall be jointly liable for damages.
And it is your opinion, it is your legal opinion, that the interpretation of that clause is that only when a state official exercises his or her position and breaks the law to the detriment only of a private individual is he jointly liable for damages. Is that your opinion?
Counselor, what this rule in the Constitution is establishing is precisely how a public official is liable jointly with the state or a state entity vis-a-vis private parties when that official causes damages to that private party. There are other sections in the Constitution and in the laws of the Republic to the effect of how they are administratively, civilly, and criminally liable for whatever infringement in the exercise of their duties in office. But this is a provision to the effect of how a public official is liable to a private party if that public official causes damages to that private party.
Right. So it's your opinion we've cited the wrong provision, but nonetheless you agree with the principle that the president, if he, in the exercise of his function, commits some or breaks the law in some way to the detriment of the state, that he could be jointly liable for those damages. He could be liable for those damages civilly and even criminally.
Well, I didn't say he'd be jointly liable because administrative legal liability pertains to the public official in his capacity as such. So there is, of course, no joint liability there.
So you agree he'd be liable himself, either civilly or
What I'm
criminally?
trying to do is to clarify for the tribunal that this is a provision that makes any public official, including the president, liable to a private party when, in the exercise of his powers, he has illegally caused damages to that private party.
And there are other provisions in the Constitution that would make the president liable, liable either civilly or criminally for actions taken to the detriment of the state, correct?
Not for the detriment of the state, for actions taken illegally.
For actions taken illegally. Okay. Now, sir, you are of the view in this case that the Lesivo law is unconstitutional, right?
Those provisions establishing lesividad are contrary to some of the constitutional provisions of my country, yeah. That's my opinion.
All right. And you, in your prior testimony to this tribunal and in your written declarations, said that you believe that if the issue were considered by the Constitutional Court of Guatemala, that they would agree that the issue or that the law is unconstitutional. You remember saying that?
No, I remember saying that it should be declared unconstitutional, not that they would declare it unconstitutional, but that they should.
And if we could put up RL 172. You are aware, are you not, sir, that the Guatemalan Constitutional Court has in fact addressed the issue of whether the Lesivo law is unconstitutional under Guatemalan law?
I am aware of this amparo proceeding where the court was asked to consider if there had been a constitutional or legal injury as a consequence of the application of those provisions pertaining to lesividad.
And you're aware that the court determined that there were no constitutional problems with the Lesivo law in this opinion?
I think that the concrete opinion of the court in this case is that there wasn't an injury that would call for granting the amparo, as we say.
Okay. The person who filed this, first of all, an amparo for purposes of the tribunal, that's a constitutional challenge to a law, correct?
Not exactly. We have a dual system in Guatemalan constitutional law. We have the review of constitutionality in the abstract, which is a proceeding, and the proceeding actually, as the court has repeatedly clarified, it is the proceeding to submit to the court, to the constitutional tribunal, that a provision in the law is unconstitutional. Then the amparo is, in the language of our Constitution, a constitutional guarantee, meaning that it is there to guarantee that the laws and the regulations of the Republic be enforced and applied, not in violation or contradiction of the Constitution or constitutional rights. So the amparo is not to review the constitutionality, but to protect individual parties against unconstitutional enforcement or application of laws or regulations.
Do you agree that the constitutional challenge to the Lesivo law was rejected by the Constitutional Court in this case?
No, I cannot agree in such broad terms. I could agree that the court in this ruling did consider whether the provisions, the very few provisions having to do with lesividad as enforced or applied to the matter brought before the court had not created an injury as claimed by the person who filed his amparo.
And so the constitutional challenge in this case failed?
The amparo failed.
Which was a constitutional challenge to the Lesivo law, correct?
Well, I've tried to clarify that for the tribunal. I think I have, I hope.
One last question.
Okay, sir, you are, where are you not? If we could put up R198. You are aware that the case that we're about to put up on the screen, R198, that in this case,
Excuse me, David, I think it's RL 198, just for the record.
thank you, RL 198, that in this case that we've currently put up, the administrative court in Guatemala overturned the Lesivo declaration by the government?
Yes, I'm aware of that.
I have nothing further at this time. Thank you.
Mr. Stern?
Thank you. Dr. Mayora, you were asked some questions about some of the legal opinions that that led up to the President's declaration of Lesividad. Could you please turn to R15 in one of the binders that you have there?
Yes, sir.
Do you have that? Could you turn to the last page of that document, that opinion, under the heading opinion?
Yes, sir.
And could you read, for the record, the first sentence there of that paragraph?
It says as follows: as explained above in this opinion, the contract is considered lesivo to the interest and must be set aside through formal acknowledgement of its condition as lesivo to state interests, early termination, annulment, or mutual agreement, taking all measures necessary to avoid incurring in acts that may cause greater damage to the assets under usufruct.
So is it your understanding that in this opinion from the Attorney General's office, they were advising, I guess, FEGWA, that there was more than one option to deal with the alleged illegalities in contracts 143 and 158 beyond declaring lesivo?
Yes, that's exactly what I read here, yeah.
Okay, and let's look at R24, which is the Finance Board opinion that you were asked questions about, or the Ministry of Finance opinion.
Yes.
And if you could turn to the last page of that under the heading 6 opinion.
Yes, sir.
And could you read item Romanet I there?
Yes, it reads as follows. First, that the state of Guatemala has sufficient grounds to invalidate notarial deeds number 143 and 158 through lesivo declaration, rescission, annulment, or mutual agreement of the parties.
And so is this opinion here consistent with the Attorney General's opinion you just looked at?
It seems to be the same opinion, yes.
Okay, could you turn to R25, which was the Technical Board of the Presidency opinion, which you were asked questions about?
Yes, sir.
And is it your understanding that this was the opinion which the President received a recommendation to declare 143 and 158 lesivo?
This appears to be the one.
Okay. And if you could go to the analysis section,
Yes.
and under item 2 there, could you read that paragraph?
Yes, it reads as follows. 2. Pursuant to the supreme law of the country, the President of the Republic may issue decrees in accordance with the Constitution and approve any accords, regulations, and orders which may be necessary to execute the laws without departing from their spirit, preside over the Cabinet of Ministers, and manage public finances in accordance with the law. Additionally, the executive branch law provides that the Cabinet of Ministers shall cooperate with the President of the Republic in establishing if administrative acts or actions are lesivo for the purposes of bringing an administrative recourse.
Okay, so is your understanding in this paragraph the technical board of the presidency was, is it your understanding that in this opinion the technical board of the presidency was advising the president that he may issue a lesivo decree?
Excuse me, he's leading the witness.
Well,
Objection.
Okay, let me ask it a different way. What is your understanding as to what the technical board of the presidency was telling the president in this paragraph here?
I think their analysis here is that they must provide the president and his cabinet, that is, with the elements necessary such that the president and his cabinet may take the appropriate determination in terms of declaring harmful an act of government, harmful to the interests of the state.
Okay, could you turn to the next page, the last page under Section 5, Opinion?
Yes.
And could you read that paragraph, please?
Yes, it reads as follows. After analyzing the accompanying documentation and the applicable legal provisions, this consultative committee understands that the draft governmental agreement, which declares lesivo to the interest of the state the contract for onerous usufruct of railroad equipment owned by Ferrocarriles de Guatemala, entered into between Ferrocarriles de Guatemala and Compañía Desarrolladora Ferroviaria Sociedad Anónima, documented as Notarial Deed Number 143 of August 28, 2003, as amended by Notarial Deed Number 158 of October 7, 2003, both authorized in this city by Notary Public Claudia Mariela Marroquín Luther, should be submitted to the President of the Republic for approval in Cabinet of Ministers.
Okay, so in this opinion, was the technical board of the presidency advising or stating that the president, that the lesivo decree must be submitted to the president for approval?
That is right, yeah.
Excuse me, must?
That it should be submitted to the President of the Republic for approval in Cabinet Ministers.
Now, you were asked questions about Articles 154 and 155 of the Guatemalan Constitution about the president's potential legal liability, personal legal liability for not declaring lesivo in that context. Let me ask you this. Can the president of Guatemala break any law by not declaring a contract lesivo when it's been recommended to him by his legal advisors?
Not in my opinion, because that determination requires the true exercise of judgment on behalf of the President and his Cabinet Ministers. Not even politically can he be held responsible, because under our system, it would be his ministers who could be called to before Congress to explain how or why they have adopted any decision that, in the opinion of any congressman, would have been not conducive to the best interests of the state. So the president there, when analyzing a matter that is being presented as harmful to the interest of the state, must exercise his best or her best judgment and determine whether that is or not the case. He is the chief of state, he is the highest authority of the executive branch, and together with his ministers, that is a moment and an occasion when he is to exercise discretion concerning the interests of the state. Matters of legality are for his legal advisors, for the Attorney General, for the courts. This is a matter of state that it is up to the President to analyze and determine with his cabinet ministers.
Are you aware of any instance in which the President has been sued or been alleged to be personally liable for not declaring a certain contract or government act lesivo pursuant to the recommendations of his legal advisors?
I don't know of any such case, sir.
Okay, thank you. Nothing further.
given your opinion that the President, in deciding on lesividad, is exercising a discretion.
That's correct, Professor Crawford.
And you say that because of that, the advice that he's given by the Secretary General and others has to be advice about framework or parameters, and not advice about the ultimate question. I don't see why. I mean, if the President has to make a particular decision, surely I'm entitled to say to him, these are the grounds for making the decision one way rather than another. I'm not substituting my discretion for his. I'm simply giving him advice as to how he should exercise his discretion, aren't I?
I think that the legal advisors ought to give the President and his cabinet advice on the legal framework within which they must analyze the substance of the problem. But I agree with you that a diligent chief of state, a diligent president, would seek the advice and the opinions of people knowledgeable about the substance of the problem that's being brought to him and his cabinet for consideration.
One of the problems we have in this case, which was described by my colleague Secretary Eisenstadt as a catch-22 situation, is that it was very unclear once things had got started how to get out of them. The original Contract 41 had been the subject of a bid procedure. The only thing standing in its way was that it hadn't been finally endorsed by a cabinet resolution. Now that meant, I mean, in accordance with the sort of legal system that I'm used to, that meant that it was probably ineffective as a contract. But it doesn't seem to me that it was, well, at least I wouldn't have analysed it as being substantively unlawful. The executive still had to do something to make it into a final contract. Whether conduct done pursuant to it was lawful or not was a separate question, but the contract itself was simply unperfected at a certain time. Do you agree with that analysis or not?
I basically do, but I would add to that analysis that the only place where an ex post ratification of Contract 41 is mentioned is the bidding terms. Because if one looks at the law that regulates FEWA and the law that created the reservership, it is the overseer that exercises the powers of the board of FEWA. And then if one goes to the Public Procurement Act, what one finds there is that it is up to the highest authority of a state entity, and FEWA is an entity. It is not an agency of the central government. It is an autonomous entity. It is for that authority to execute the contract and create, as in this case, a usufruct. So I agree with your analysis, but I don't think that, A, one can create an obligation for the President to ratify a contract through an executive decree, and B, that the lack of such decree or accord is not going to have or shouldn't have any consequence in terms of the validity of the contract.
Let me give you a hypothetical, which the relationship of which to the present case can remain unresolved for the purposes of the question to you. Let's assume that a foreign investor engages in a bid process, wins the bid fairly and squarely, makes a substantial investment, does everything that is required to be done under the contract which is then negotiated. But the contract is, for some reason, not ratified by a government resolution as it should be. Does that mean that, as a matter of Guatemalan law, there is no alternative but a declaration of lesividad in relation to that contract, or alternatively, the conduct of a completely new and open bid procedure which our putative investor may lose?
in my opinion, there are several courses of action that the government and the state entity, in this case FEWA, and the private party to the contract could have pursued in order to cure or resolve the alleged lack of ratification. And very probably the easiest one would have been to just amend that contract and remove the requirement that it be ratified by executive decree, because again, neither in just the terms of reference of a bidding process nor in a contract can anyone make the president obligated to issue an executive decree ratifying the contract that an autonomous entity has the right through its highest authority to enter into and negotiate.
Just adding further to this hypothetical of Professor Crawford, you mentioned amending the contract and removing the requirement of executive ratification. We're told by the prior witness, the overseer, Mr. Gramajo, explicitly that this contract, that is 143 and 158, did not require executive approval by its terms, and that the FEGWA lawyers, after it was in effect, then concluded that it did require executive approval. In other words, it's not a question of correcting a contract which did require executive approval and then changing it. In his testimony, the contract did not require executive approval, and the lawyers determined, FEGWA lawyers, that it did require it. Does that, how do you, that's what I call the catch-22, but how do you deal with that situation? What is your opinion on that?
It seems to me that the nature of the problem stems from the inclusion in the terms of reference of the bid that any such ratification was required. And I ignore why such thing might have been included. Probably they were seeking to provide the whole process with more formality in having the President and his cabinet issuing any such ratification, or but it seems to me that the two parties to a contract acting in good faith and trying to converge in making the situation work can find several ways to amend the situation, because in my opinion this was really a legal technicality. In substance, the President, his cabinet, the whole government not only approved of this process, they promoted it, they organized it. An overseer of FEWA or any other state entity couldn't have conceivably, not possibly, started a process to privatize the service. This was wanted and promoted by the government, by the President himself, and so to speak of a lack of approval, it's, you know, it can only be said in a very formalistic sense. And so I think that there would have been several ways to amend the contract and to correct this technicality.
Without a declaration of lesivo.
Right.
Do you know whether under Guatemalan law there is something equivalent to a sort of common law concept of estoppel or reliance when one party has relied on the actions of another? Is that a doctrine that is embedded also in Guatemalan law?
Yes, Secretary Eisenstadt, it is. It is in our civil code, and clearly stated in it is the notion that a party that has contributed in any way to the creation of a cause for nullity cannot invoke that in order to obtain a declaration that the contract is null and void. That's the reason why I've maintained that a declaration of lesividad can only be considered as an exception to that rule, because the general rule is that of the common law notion of estoppel, which we have a similar sort of principle or rule in our civil code.
And we've heard at least some testimony that the FEGWA overseer signed contracts 143 and 158 after, by mutual agreement, contract 41 was set aside as being null and void for the absence of presidential approval. And the overseer presumably signed that agreement, signed by both sides, and there was action pursuant on both sides to that contract. Is that a situation, in your opinion, in which this doctrine under Guatemala law of estoppel would have relevance?
I think so, because this is a situation where the party exercising control over the fact or the factor that would have cured the problem is the very government. In other words, the private party cannot do anything to have the president ratify Contract 41 or any of the other contracts. This is something that's in the control of the government, and if they decide not to do it, well, then I would think they are stopped from bringing that as a cause for nullity.
Now, we're, of course, we're making a judgment, as Professor Crawford has said, under CAFTA, so this is a separate decision that we have to make. What criteria are there for invoking lesividad? Are there stated criteria beyond the president's making a determination of the interests of the state of what types of judgments must be made to make that determination that a particular act or contract is contrary to the interests of the state? Or is it a purely discretionary matter? What do you know of what criteria in terms of previous, either statutorily or by court decisions over the years?
There isn't any criteria, no settled criteria as to what might be harmful to the interests of the state within the context of lesividad. There can be 4 people and 6 opinions as to that in a room at any given point in time, and unfortunately the few cases that in the last 25 years or so have made it to the administrative court have not, in my opinion, shed any light on that.
If FEGWA had decided, as they presumably did, that a executive approval was required for these contracts to be fully effective and the alleged illegality removed, would the president have been authorized to grant that approval as opposed to granting lesividad, or would that have been beyond his authority to do?
In my opinion, that probably would have been the harder solution, because again, there aren't any specific legal provisions on the basis of which the president can issue such ratification, and the president or any other public official requires a legal basis for action. And where is the provision on the basis of which the president could have issued such ratification? So that's the reason why I venture in my opinion that the easiest way would have been to clarify the record to the effect that no ratification is required only because someone decided in the bidding terms that it was a good idea to have that.
Is there such a thing in Guatemala law as no bid contracts? Do you have that as a possible avenue for public contracts?
There are some exceptions in the Public Procurement Act where contracts can be entered into without a bidding. Cases of emergency where national security or where there's only one supplier or there's an intuito persona kind of situation, but most of them are exceptions to the general rule that a bidding is required.
Do you have any opinion under Guatemalan law as to whether there having been a bid for Contract 41, which was then superseded by 143 and 158, there was a requirement for a rebid of 143 and 158?
In my opinion, it is very important to point to the very specific object of the bidding. The bidding was in order to acquire the right to negotiate a usufruct contract with FEGUA. So the winning of the bid was supposed to go and sit down and within the general terms of the bidding process then negotiate and conclude a contract. So I think that this being the object of the bidding process, there is reasonable grounds to look at contracts 143 and 158 as the final stage in these negotiations that one would want to think of as bona fide negotiations leading to that sort of final concretion of the process. A second bidding would have, I think, been an implicit recognition that no rights existed, that the whole process had been somehow null and hadn't produced any effects, and I fail to see how that would have been a cure. I think that would have been another way to kill a process that was certainly promoted by our own government.
One last question. Under Guatemalan law, but also your experience in the country, we have a situation here in which there were two separate contracts, one 402, which granted certain rights of way and control of rights of way, which was not implicated in the Lasividad. And the second, the equipment, 143, 158. Do you have any opinion as to whether, if there had been a rebid of just the equipment contract, there would have been a likelihood of another bidder bidding on that when that bidder would not have controlled the right of way for the use of that equipment?
In my opinion, the probability would be very, very low, close to nil, because the other bidder would have had only one other party to enter into a contract with for the use of the right of way, and so I wonder who would enter into a situation where there's only another party in the world to contract with in order to use that equipment. I find it very, very improbable.
Thank you.
Dr. Mayora, you said in respect of the contract 143, etc., in terms of possible ratification by the President, that there was no specific provision under which the President could act, which is why you suggested other ways to solve this problem. Nonetheless, under Contract 402, was ratified, was approved by Acuerdo Gobernativo after bidding. So it's something that had been done before. Do you have any comment on that? In terms of your statement right now on this matter?
Mr. Chairman, I think, if I'm not mistaken, that 402 was ratified by Congress, and probably that was done on the basis that Congress approves concessions. I don't know, to be frank. But if there would have been also an executive decree ratifying Contract 402, it might well have been considered an ultra vires action on behalf of the President. Yeah.
I don't recall whether it was Congress or was the government at this point. So it just occurred to me as I heard your statement that there had been the approval of the previous contract. Thank you. Mr. Stern, do you have any questions on the tribunal questions?
No, I have no further questions. Thank you.
Mr. Orta?
Thank you, Mr. Chairman. Just following up on some of the tribunal questions, I'm going to start with a question by the chairman. Is it your view that the president, if the contract were submitted to the president, is it your legal opinion that he couldn't approve it because there was no basis upon which his executive approval should have been sought in the first instance?
Yeah, it is my opinion that there aren't provisions in the laws of Guatemala or the regulations on the basis of which such presidential ex post ratification could be given.
And as you said, your recollection is that Contract 402 was only submitted to Congress for approval. You don't have a recollection that it was also submitted to the President for approval?
I don't have that recollection right now.
Okay.
I do know that Congress did pass a resolution ratifying 402, but whether it was also sent to the President, I don't recall right now.
Thank you. In terms of options that were available, you said there were a number of options, and now we're talking about Contract 41 for a second. You said there were a number of options available to the parties. Was one of those options that Ferrovías could have formally petitioned the office of the President for approval, having not received approval of the contract, that it could formally have petitioned the office of the President for it to approve Contract 41?
On the basis of a technical petition or a petition on the basis of technical legal grounds, I don't see how that was possible, because again you have to go to the Secretary General and say, I come here to petition on the basis of Article ABC that Mr. President shall ratify this contract. And so what's the basis? The strongest basis again would have been there are these terms of reference for this bidding process, and it says that Mr. President must ratify this. So I petition that he does.
So let's assume for a second that you're incorrect in terms of your opinion that executive approval is not required. There's been another opinion rendered in this case by a different Guatemalan legal expert who has opined on the basis of other Guatemalan laws, including the organic law of FEGUA and the Constitution, that executive approval was required. So for purposes of this question, assume that that is the correct opinion of whether executive approval is required. If you make that assumption and there was no approval from the President forthcoming for Contract 41, could Ferrovías have petitioned the Office of the Presidency for executive approval of Contract 41?
For a second time, you mean, or just once?
Having not received approval from the President.
Initially, you mean?
No. Once the contract was signed, okay, so that's the starting point. Once the contract was finally negotiated and signed, and let's assume again that executive approval in this hypothetical is required for this contract in order for it to become effective. Was one of the options available for Ferrovias to petition the president at that point to approve the contract under Guatemalan law. Was that an option they had?
You know, on your assumption, it was an option because, of course, the assumption is the highest premise, yeah.
Okay. And under Article 16 of the administrative law, if the president had not answered that petition within 30 days, that would have been the equivalent of saying no to that petition, correct? It's the principle of administrative silence.
That's correct, yeah.
And if Ferrovias had made such a petition and had either received a no or received no response after 30 days, they could then have filed an action in the Guatemalan courts to compel the president to sign or to make a determination, I should say, about whether or not to approve the contract, correct? That would have been a remedy that they had after they got the either the no or the effective no through administrative silence.
Well, probably not to the administrative court. Perhaps it would have been more of an amparo action. But again, the fundamental point here is that if there were any provisions in our statutes mandating that presidential ratification, I suspect that we wouldn't be sitting here.
Now, you said that no executive approval was required because, in part, you say the executive gave his approval when he agreed to the bidding process, correct?
No, I'm saying that to maintain that there wasn't a governmental approval of the whole process is impossible to maintain. That the only thing that one could discuss is whether a formal presidential ratification was legally required or not, because it was the very president and his government who promoted the privatization processes, not only of the railway system, but the post office, the telecommunications company, the electric sector, and on and on. So this was a national project at the time. So to characterize this as lacking presidential approval, in my opinion, can only be said in a very narrow formalistic sense and as a ratification ex post, not ex ante.
Now, you did say, though, that the parties, according to the bidding terms, could negotiate certain terms of the equipment contract, right?
What I said is that the terms of reference of the bidding process had as their object the right to sit down and negotiate the usufruct contract with FEWA.
And that certainly, whatever those terms were that were eventually negotiated by the parties, that's not something that the president could have given approval of in advance, correct? Because he wouldn't have known about what those terms were going to be, that the parties would eventually negotiate.
I'm sorry, I'm not sure I'm understanding your question. Whether the president would have approved in advance the terms of reference?
Not the terms of reference, the subsequent additional terms that the parties were to negotiate between each other. That's certainly not something the president could approve in advance, correct? He wouldn't have known what those terms were going to be.
No, and he was not required to do that under law.
Okay. In terms of the bidding law, first of all, you do agree that the bidding terms, Article 6.4 of Contract 41 required presidential approval, correct? You said that before.
They've included that, yeah.
Yes. And you also recognize, don't you, that the bidding, those very bidding terms were incorporated in Contract 143.
Yeah.
And so by incorporating those bidding terms into Contract 143, they were incorporating all of the terms, including the one that required executive approval, correct?
Yeah, you could say that, yeah.
And you're familiar with Article 89 of the bidding law, correct? Or of the public contracting law?
The one in force at the time?
Yeah, the one in force in 2003.
Yeah, I'm familiar with it.
And Article 89 of the public bidding law requires that a contract that arises out of a public bidding process comply with the bidding terms, correct?
Yeah.
So in other words, it would be incorrect to incorporate terms of a bidding contract that required one to do X, but then one to not do X. That would be incorrect under Article 89 of the bidding law, of the public contracting law.
Yes, of course, as we all know, on the basis of the rules of logic, 89 cannot possibly be construed to allow for the inclusion of bidding terms above the law.
Right, and I guess the basic point is, if the bidding terms say you have to do X, and you incorporate those bidding terms into a contract, then you have to do X in that contract.
If it's legally required or mandated, because the terms of reference are no legal means to amend statutes or to amend regulations.
I have nothing further, thank you.
I just have one more question that we didn't get into. One of the issues that we have to face here is whether the declaration of lesividad was in effect a final action or simply a process, given the fact that it could be appealed and that the administrative court has to make a final judgment. And I think this has been pending around 4 years now. Do you have any opinion about the finality or impact of the lesividad declaration when you have a judicial review that's available and that is still going on as we speak?
Well, in my opinion, the whole design of the institution of lesividad is of such nature that, as I've argued in my statements, in my reports to the tribunal, it becomes almost final. And that is in part due to the object of the declaration of lesividad, namely harmfulness to the interests of the state. And B, given the very unfortunate situation that the court system in our country is currently not providing the adequate protection of the law. In general, I think this is a notorious fact and something that makes us very sad and very concerned, but it is a reality. And so in that setting, a declaration of lesividad has almost the practical effect of destroying the business or making it very unlikely that it could be viable again after years and years of litigation.
Mr. Stern, anything on that question
No,
from your side?
I have nothing further.
Mr. Horta?
Just one. You agree, don't you, that it is the administrative court who ultimately decides whether the contract is lesivo or not?
Whether there are legal grounds for the declaration of lesividad.
And whether lesividad exists. You agree that it is up to the judicial administrative court to decide whether lesividad exists, don't you?
Well, again, I've honestly tried to explain the difference. The declaration of lesividad is made by the President and his cabinet. It is submitted by the Attorney General to the administrative court for a review of that declaration, but the declaration of lesividad is made by the president and his cabinet.
Okay. Do you recall testifying before this tribunal back in 2010?
Yes, I was here, yeah.
Okay. Can we put up page 823 of that testimony? And this is testimony that you, sir, gave before this tribunal on March 3rd, 2010, in the hearing on jurisdiction. And if we could highlight, please, lines 12 through 14. Now, you were asked a question then, and the question was, it's the judicial court who ultimately decides whether lesividad exists. Is that the case? And you answered, ultimately yes, correct?
Correct.
So which version is correct? The one that you gave to the tribunal then, or the one that you rendered today? Because you gave a different answer today.
I don't find it different. I find that I'm trying to explain that the declaration of lesividad, which is the act of government, as defined in the Ley de lo Contencioso Administrativo and in the Administrative Law Act, that is for the government to make, for the president and his cabinet. That goes for review to the administrative court, and ultimately the administrative court decides on that.
Decides whether the lesividad exists, correct?
Yes.
Thank you.
Muchas gracias, Dr. May.
Thank you very much, Mr. Mayura. Thank you, Mr. President. You can step down. Thank you.
Now, and reconvene here at 3:45.
Thank you.